Hello again. This is Ben Hitchcock Cross talking to you today. We're going to go through some Gelhard responses, and we'll see how the judge here, I guess we'll go to me, the judge responds to the rules, and if there's decisions are rules-based or something else. So let's remember an ALJ only has 9 powers: to administer oaths, to issue subpoenas, to rules on offer of proofs and receive relevant evidence, to take depositions, to regulate the course of the hearing, to hold conferences for the settlement and simplification of the issues by consent of the parties, to dispose of procedural requests on similar matters, make or recommend findings of facts, conclusions of law, and decisions to the extent permitted by law, or take other action authorized by agency rule consistent with this chapter. All right. 9 simple rules to live by. All right, so here we go. Now, there's a rule that says that hearings have to be held in the county in which they happened unless there is consent of the parties. Okay. So let's go up here, and I say, Judge, on October 19th, you unilaterally decided that the hearing would be held via WebEx. And then here's his email. Thursday, October 19th, 2023. Let's go with January 31st. The hearing will be conducted via WebEx videos. Both the parties will provide hard copies. Let me pause this one. All right. I hope you can see all of it, but hard copies or potential exhibits to the hearing. Witnesses should also have hard copies of potential exhibits in front of them if they are going to be examined on the documents. Okay. So then I say that's his thing. The tribunal's decision is erroneous because it is ultra vires. I'm sorry if you can't see that better. I don't know. Let's go. DWD 218.11 sub 2. Now that's a rule, remember. And so this is falls under I, take other action authorized by agency rule consistent with this chapter, okay? Now it says place of hearing. The hearing shall be held in the county where the alleged act of discrimination occurred or at another location with the consent of the parties. For the purpose of this subsection, the county where the alleged act, yada, yada, yada. Okay. And then I say, kindly conform to the regulations. Okay. So his response is this. And we're going up from the bottom, but it's just absolutely true. And he says, since Attorney Cross, since 2020, the ERD has been conducting hearings via WebEx in response to the COVID-19 pandemic. I believe you have participated in ERD hearings via WebEx video. True, with my consent. In this case, I circulated potential hearing dates on April 18th, 2023. You failed to respond to my email. So, and it's absolutely true that there are a significant number of emails that I didn't respond to by providing dates. What we did respond to was sending letters to Amy Petchacek and the judge saying that they needed to notify all DOC employees of the fact that Amy Petchacek was making decisions and at the DOC in conjunction with Carr, and is now the DOC, the DWD secretary. That's what we said, and that we said it was improper to have any hearings or to schedule any hearings until that issue was resolved. Well, the way they resolved that issue was by ignoring it and refusing to respond. So that is how we ended up having a delay of almost a year on the hearing, because they refused repeatedly, both the judge, the judge did not respond on this until October, when I again reminded him of the Supreme Court's ethical requirements to be candid and to notify people of potential conflicts of interest, third parties, in fact. So my contention was that he was required the entire time to notify my client that he had a conflict because his boss, Secretary Petchacek, was an alleged bad actor in this case. And he refused to do that. He decided on his own evidence that there's no conflict of interest between him and Secretary Patrichak. But I don't feel like that's how that works, but okay. So then I said that same day you responded by saying, I'm fine on dates, yada, yada, yada. Okay, let's get down to it. We're getting down to October 19th, 2023. Yada, yada, yada is a little flippant. I don't want to say that. He does actually respond here with some substance of, it's all your fault. Okay. On October, but now it doesn't matter because he didn't issue a scheduling order until October 19th of 2023. That's the fact. Okay. The January dates are fine because the 6 weeks had elapsed. I had to inquire from whether she was available she was confirm the availability. Okay. Was mailed out to both. The hearing would be held on January 3rd via WebEx attached to this email. Part of the reason in selecting a WebEx hearing was the fact that the complainant was later in Watertown. Witnesses for either party could be located in various locations throughout the state. One attorney was in Milwaukee, one attorney was in Madison, and the fact that there was a possibility of inclement weather in January. Okay, you can take it from me, although I'm not 100% sure, that scheduling order does not say anything about inclement weather in January or anything about his reasonings whatsoever. Okay, that's post fact. And again, it doesn't, okay, we'll just keep that reasoning on its face, okay? So does the fact that there's one attorney in Madison and one attorney in Milwaukee, does that change this rule here that says that it's got to be in person unless the parties agree? Should be located in the county where the alleged action occurred or another location with the consent of the parties. Okay. So does his reasoning about inclement weather, does that change the consent of the parties? I don't hear that being a response to that at all. Okay. Now he says another reason. I don't believe the purpose of DWD 218 is contravened by utilizing WebEx as a means of conducting the hearing. Okay, I'll keep that in mind for future reference. So I think what he's trying to say is that even though nobody may be actually in the county, it's basically the same effect as having it be in the county. Do you know why? I don't know why. He believes it. I don't know why he believes it. But I don't know that matters because it says shall be conducted in the county. So does virtually mean shall be conducted in the county? And if the attorney's in Madison and the judge is not in that county, does that mean that it's being conducted in that county? I don't get that sense. Let's put it like this. We shouldn't have to guess at why that's the case. He needs to explain why that's the case so that we can then say that, yes, that's acceptable reasoning. We won't challenge that further, or no, it's not acceptable reasoning. We're going to challenge that. That doesn't do that. Okay? Sorry, guys. I guess you can't see that. More than 3 months have passed since the scheduling order was mailed to both parties. At no time during the attempted scheduling of this hearing or since the scheduling order was issued did you raise the issue of an in-person hearing. In fact, you raised the issue less than 1 week before the scheduled hearing. It must be concluding that your request for an in-person hearing is not timely. I didn't request it. Did you see me request anything? The hearing will be conducted via WebEx video on January 31st of 2024. Now let's just look again here. The tribunal's decision is erroneous because it's beyond its powers. To my certain knowledge, the employee has not consented to another place of hearing, nor has it ever been heard on that issue. Kindly conform to the regulations. It's not a request. That is, you do not have the power to do the thing which you claim to have the power to do. You need to fix that. He doesn't address whether or not he has the power. He's saying that because you didn't do X, Y, or Z thing, then I don't have to follow the rules. That's what that is. Not in a nutshell, 100%. Okay? Let's go through that again. Mailed out, witnesses. One attorney was in Madison. Okay. The fact that that first paragraph is, I had a secret reason for doing what I did against the rules. Now I'm telling you what that reason is. Okay? That fails because there's no reason that allows you to break rules. There might be if you had some inherent powers, but when you only have statutory powers, there is no reason that allows you to go beyond the powers that you have. No reason. You cannot come up with a reason that allows you. Meteorite comes down. Nope. Act of God. Nope. Insurrection. Nope. It would be fair. Nope. Best interest of the employee. Nope. Politically expedient. Nope. None of those things work. If there is a rule and you are a creature of that rule, you cannot go beyond it. No matter what verbal gymnastics you may claim, you cannot go beyond it. Okay? So that the rule doesn't count because that's that phrase. Again, as a ALJ, as a hearing examiner, there is no decision that you can make that starts with the rule doesn't count because. As soon as that comes out of your mouth, it is an illegal decision. Now, point 2 here is it's all Ben's fault. Therefore, I can break the rules. Okay, that's another same variation, same thing. More than 3 months have passed since the scheduling order. Ben is a jerk because he didn't do anything for 3 months. Okay, Ben didn't tell me that I didn't have this power until now. And I've been assuming incorrectly that I could do something that I couldn't do. So we all sort of rested on the fact that I did something that I don't have the power to do. So therefore, now I have the power to do something I don't have the power to do. It must be concluded. Now, that's passive voice alert. That your request for an in-person hearing is not timely. Again, we didn't request an in-person hearing. We pointed out that the law requires a hearing in the county in which the discrimination contends unless the parties agree otherwise. Period. The end. The judge does not have that power. The parties have that power, which means the employee has the power of no. They want to take that away from the employee and put it in their hands. They cannot do that. That's what you call a power grab. They cannot grab that power. It's not theirs to grab. They cannot touch it. The law says who gets it, and it's not theirs. The rules, let's remember, take other action authorized by agency rule. He is not authorized by agency rule to come up with a WebEx hearing, to hold a hearing not in the county in which the discrimination occurred. That's it. And whatever Ben Hitchcock Cross does or does not do does not change that fact. Whatever the employer does or does not do, whatever the employee does or does not do, does not change that fact unless the employee and the employer both agree to hold it somewhere else. That's it. He never asked. We did not offer. Based on, those are the only critical fact. The only fact is whether or not we agreed. Do you see how this is? This is very indicative of the style here. And we'll have other examples. I think I'll pull up another one. But that is the concept of how these things, the approach, that's what we want to focus on. The approach is not from the law. This is not a laws-based approach. This is what the judge feels like an approach. They can't do that. Let's see how I respond. And just let's be clear. I sent this on January 25th to John Gelhard, that's the judge. Zacard, that's the opposing counsel working for the DOC. Jennifer Wackenhauser, that is Secretary Petchacek's personal attorney at the Department of Workforce Development. She's the attorney in the cabinet. Ramona Natera, that is the administrator of the Department of Workforce Development, the person with the power to hire and fire John Gelhard, the supervisor of John Gelhard. Okay? And then we've got Nola Hitchcock Cross, my boss, I guess is the best way to put it. Hey, that rhymes. The managing partner here at Cross Law Firm. And I think somebody who is an indication of several things. One, that we're taking this extremely seriously. And two, that we think this has gotten out of hand. By we, I mean me. Now, none of those reasons are factors. You have pointed to nothing which authorizes, I do say with, authorizes you to change the rule. There is always time to follow the department's own rules. The department should have been following them 4 months ago. A laws-based approach is the way forward. Now, I think that says it all, really, right there. I think that says it all. A laws-based approach is the way forward. And how could they disagree with that? We'll see. All right. So here we are. This is getting down into dirty, of which I have only alluded to. But this is in my email in response to the misquoting of the statute. And it says, first and paramount, you have appear to have purposely misquoted the statute. You quoted, quote, require the party or deponent whose conduct necessitated the motion or party or attorney advising such conduct or both of them to pay the moving party the reasonable expenses incurred in obtaining the order, including attorney's fees. The actual statute reads, if the motion is granted, the court shall, after opportunity to be heard, require the party or deponent whose conduct necessitated the motion or the party or attorney advising such conduct or both of them to pay to the moving party the reasonable expenses incurred in obtaining the order, including attorney's fees, unless the court finds that the opposition to the motion was substantially justified, or that circumstances make an award of expenses unjust. You can see how that without those first phrase and the last phrase, you get a completely different meaning from the middle phrase. You can see that. So based on this is me reading again from this letter, based on the misleadingly truncated portion of the statute you excised, an ALJ is without authority to order any expense unless and until the deponent has had an opportunity to be heard after the motion is granted. It is hard to escape the conclusion that you know this rule and excised the relevant and dispositive statement of law from your email because you knew that it contradicted your order. We pause here to note that this is nothing more than statutory reflection of what the legislator believes is the process due to the non-moving party, a theme we have repeatedly remarked on the lack of process due afforded by this tribunal. Any plain reading of the remainder of the statute also makes it clear that your order is erroneous. To pay to the moving party the reasonable expenses incurred in obtaining the order. As a threshold matter, the only expenses are those incurred in the obtaining of the order. There is no evidence, nor could there be, that the Department of Corrections incurred an expense that has not happened yet. Nor is there any evidence, nor could there be, that an expense that has not happened yet was incurred in obtaining the order. Note that use of the past tense by the legislature to indicate that the expense must have already been incurred. Therefore, your order does not pass a plain reading of the statute, even the misleadingly truncated one. Yowzers. Finally, you may wish to characterize a fee of a court reporter as an expense, not as a sanction. However, the law does not agree with you. And then we've got some citations there. So now kindly advise us how your order is legally cognizable and why you chose to remove the due process protections embodied in the statute when you made your statement of law. Signed, yours truly, for equal protection. Okay. So let's now look and see, I think, what is being said. Let me find it. I just want to show you for the record what he actually wrote. He says the language of the statute is, quote, require the party or deponent whose conduct necessitated the motion or the party or attorney advising such conduct or both of them to pay the moving party. Okay, this is his quotation of the statute. Now let's look at his response. You filed an 18-page response to the motion to compel. Nowhere in your response did you ask for a hearing on the motion to compel. Nowhere did you argue opposition to the motion was substantially justified or that other circumstances make an award of expenses unjust. Okay. That hurts my brain a little bit, but let's try to say that again. I filed an 18-page response, Ben Hitchcock Cross, that means the complainant, not me personally. His personalization of me is rather inappropriate. You filed an 18-page response to the motion to compel. Nowhere in your response did you ask for a hearing on the motion. Okay. Nowhere did you argue opposition to the motion was substantially justified or that other circumstances make an award of expenses unjust. This falls under the argument of you should have told me not to do something illegal before I did the illegal thing. I'm going to modify that portion of the order regarding the upfront payment for the deposition with the ultimate issue of who should pay for that deposition to be determined at a later date. All aspects of the order remain in effect. The amended order will read. Okay? So he sort of changed some of it. But again, it's this logic here that says that you are supposed to tell me, if you don't tell me that I can't break the law and I break the law, it's on you. If you don't tell me that we can't hold a hearing remotely because that's what the rule says, and I break the rules and try to sneak it by, and then I get away with it for 4 months, then I've gotten away with it. That is not an acceptable form of reasoning. This is the most senior administrative law judge, I believe, possibly with one exception, working out of, I think, 20, working at the Department of Workforce Development. The most senior. This is extremely concerning for anybody who believes in the rule of law. That's all there is to it. It is never the responsibility of I'm sorry, let's just back up 1 second. Did I make him misquote the statute? Because how do you get the middle part of a statute without looking at the first and the end? Did the employee make him misquote the statute? Did the employee make him schedule it unilaterally by WebEx? That is not an adult frame of mind. It's not a professional frame of mind. It is not an acceptable frame of mind for anybody who is making decisions on this level that are binding on anybody. It is unacceptable to put blame for your mistake onto somebody else. And it's not just a question of maturity. It's a question of, if this is what you're exemplifying, I'm going to give my rationale after the fact, and you should have read my mind and known what the problem is. You've got, I mean, it just doesn't work like that. It does not work like that. It needs to work on the basis of rule of law, which are, this is the rule of law right here. That's what it is. You should have told me what the law was, and there's 9 rules. There's 9 of them. It's not that complicated. You should have that language memorized in 30 years. You should have every single rule memorized in 30 years. But no. It's on the employee once again. The burden is on the employee to make them do their job. And then when you say, hey, what about this rule that you just violated? Then you're the jerk. Then the employee is going to get retaliated against. This is a fundamentally untenable situation, and it needs to change. Tony Evers, I'm looking at you. Ramona and Tara, I'm looking at you. Something needs to be done. To ask an employee to go to a hearing under this circumstance is outrageous. This is not what Wisconsin stands for. This is not the Wisconsin that I grew up in. It's unbelievable. It's not the rule of law. It's not the process due. Something must change, Ramona and Tara. And it starts, you are the one with the responsibility and the authority. That's why you are the administrator. Something needs to be done. This kind of conduct cannot continue. Stick with us. We'll keep you informed.